The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
In opening statements yesterday, prosecutors said Sam Bankman-Fried's crypto empire was a house of cards that was built on a lie. The defense countered that the FTX founder acted in good faith while also assigning some of the blame to ex-Alameda CEO Caroline Ellison, claiming that she failed to install safeguards. Joining us now to discuss is ZFZ Law co-founder Michael Zweiback. Welcome to the show, Michael.
Thank you very much.
All right. You are very experienced in white-collar criminal defense. What did you make of the opening arguments that we heard yesterday?
Well, both sides did what they wanted to do. The prosecution stayed away from sort of the more difficult topics and tedious topics of the world of crypto, and they focused on lies, lies, and more lies. And the defense attorneys did what they had to do, which is they're trying to paint Mr. Bankman-Fried as just sort of a CEO who was making it up as he was going along, and it's not really his fault. There were other issues, the market, Caroline Ellison, that really were responsible for the fall of FTX.
You talk about the tedious aspects of crypto here. If just one juror feels confused about the different aspects of the crypto industry, what could happen?
Well, that could lead to the possibility of a hung jury if, in fact, they believe that it was really market forces as opposed to Mr. Bankman-Fried's actions that resulted in the failure of FTX. But I think the prosecution has done a very good job at trying to make this more about the garden variety fraud aspects of this, the lies, the attempt to gain political influence. And that's where they're going to focus their attention and not on those more difficult aspects.
Does the idea that it's making it up as they're going along, is that going to really help Sam Bankman-Fried? In other words, even if they do show, even if they're somehow able to portray that idea, if he was making it up as he was going along, including trying to cover his tracks because he was so upset about what was going on, he was just trying to do the right thing here. Is that going to help his defense at all?
Well, I don't think so. I mean, they're trying to put it on the fact that he was acting in good faith, that he didn't have the intent to engage in the crime. And you're going to hear that he was relying upon some of the world's best law firms in order to provide the compliance elements that were necessary. But ultimately, I think you're going to be able to see, and the prosecution is going to paint the picture that this was far beyond good faith, and this was about his own personal ego and the use of investor funds.
So it's funny because a lot of people are talking about, does the jury understand crypto or not? But it seems like it's not really an understanding of crypto. It's more of an understanding of just like this very specific business of FTX, which, to be frank, most people in the crypto industry don't really understand. Like FTX was extremely confusing, right? I mean, like, what exactly were they doing? And I feel like this is where problems will arise, because it's like when they try to explain, okay, the relationship between like FTX and Alameda and like high frequency trading and futures. I mean, this is actually legitimately quite complicated and was bewildering. Like, how do you deal with that? Because I feel like this isn't about blockchain technology. This is about like an admittedly very confusing business.
This is about a bad business or a sort of a business that lacked transparency. And so what the prosecution is going to try to do is ultimately they're going to focus on the fact that he used $10 billion for political influence and buying multi-million-dollar properties. The fact that that amount of money was used from investors directly is going to be the picture that's going to be painted, and it's not going to be focused on those other very tedious aspects.
But, we sort of talked about this a little bit before on the show, and this is where I'm having trouble getting my head around it because, as we know, crypto exchanges are not regulated at a federal level in the United States. This wasn't even a United States exchange, right? So, like, isn't there some world in which the defense could say something like, well, nobody told us we couldn't use customer money for this? I mean, because, for example, if the U.S. had some federal regulation saying, like, assets need to be segregated and customer funds cannot be used for trading from a sister company, but there's not actually a rule that specifically says that, right? So, I mean, is that something that they're expected to argue?
Well, they're going to try to argue that. They're going to try to argue that this is not like a bank or any other financial institution, and that the rules were different for them. And in fact, in many cases, the rules just didn't exist. But the focus is going to be on what did they say to the investors in order to get them to part with their money. And that's going to be a much easier road for them rather than focus on these other issues, the compliance issues that, that have been raised early in the case.
So who's going to be helped by the kind of jury that was selected? Is it going to be the defense or is it going to be the prosecution? A jury that might not necessarily know a lot about crypto. We see now the kind of witnesses they're going to call up, et cetera. Who's going to be helped here?
Well, ultimately, I think, arguments could be made that it could help either side. The fact that the jury is not sophisticated in crypto is going to tend to cause some confusion as these things are trying to be explained. But I think that the prosecution, as you saw in their opening, is going to focus on the very simple aspects of the fraud. And that, I think, is going to be easily understandable to this jury that's been seated.
Is the Sam Bankman-Fried, are the jurors being sequestered? And if not, how is the court ensuring that they're not watching shows like this and their opinion isn't being swayed?
Well, as you saw from jury selection, everyone had heard about this case. So I think in a circumstance like that, where everyone has heard about this case, you have to do a very careful jury selection, make sure that you're vetting everyone to ensure that there are no sort of preconceived notions about the case. And it comes down to the voir dire, or the questions asked by the judge of each and every juror. That's the most important part of that.
So just to follow up on that question, there's this kind of weird elephant in the room, which is this Michael Lewis book, right? Which is like this very, crypto community is very angry because they see it as overly sympathetic to SBF. And, you could say like, oh, it doesn't matter. It's just a best-selling author, spinning his usual tale, except for the fact that Michael Lewis himself referred to his book as a letter to the jury on 60 Minutes. And so where does this book fit in? I mean, like, what do you even do with that? It's like, I'm just curious, like, obviously there's no way to enforce whether somebody reads a book or not, but I don't know. Where does this book fit into this whole conversation?
Well, I think it ultimately play very little. I mean, the judge has asked questions about what they read and what, sort of what experience they've had with the case. And so that type of thing would have come out in jury selection. I understand that the book is very popular, but I think you're going to find that it plays very little in this case. It's going to be about the witnesses who are sort of inside the boardroom who are going to explain what Mr. Bankman-Fried's intent was.
I'm curious to hear what you think of the defense strategy. Of course, we now know that there's going to be some blame put on Caroline Ellison, who's the former CEO of Alameda Research and also alleged ex-girlfriend of Sam Bankman-Fried. There is we're thinking the defense is going to blame some of the attorneys that advised Sam Bankman-Fried later on in the trial. What do you make of this strategy?
Well, it's really the only strategy they have. I mean, it's got to be, I'm just the poor math nerd from MIT, and I was trying to build this company with all the best intent. And so it's really the other people who I relied upon who failed me. Caroline Ellison failed to follow my instructions. And while I did the best I possibly could to follow the advice of my lawyers, in some cases I may have failed. Being a bad CEO does not mean that I have the intent to commit fraud. And that's really the only thing that the defense has to rest its hat on in this case. I think it's going to fail.
And ultimately, as you sit and watch this, how in using past history, what do you suspect will happen at the end of the trial, should he be found guilty? I mean, is this going to be kind of is he still going to get like a tap on the wrists here, so to speak, maybe a dozen-year in prisons, or do you think that this will just be a really, he'll be collecting his Social Security checks behind bars?
I think you're going to see a Bernie Madoff type sentence. I mean, this is going to be a substantial sentence. If Mr. Bankman-Fried does get out, I think he's going to be collecting Social Security by the time he does get out.
Wow.
All right. And Bankman-Fried, during his time at MIT, actually walked the jury through a brief set of explanation about crypto. Talk to us about if crypto, I know we already spoke about this a little bit, but like, do you think that one juror is going to feel hung up on this and we're going to get a hung jury by the end of this?
Oh, that's entirely possible in any criminal trial and in any federal criminal trial, and especially in fraud cases. I mean, they can be complicated. You do get jurors who get hung up on the details and the tedium. And look, the prosecution had a good first day, but it doesn't mean that the second and third are going to be similar. And, you're expecting that these witnesses, the insider witnesses, are going to testify as they've indicated to the court in their guilty pleas, but sometimes things happen, and so you couple the detail and the tedious nature of the testimony on crypto with the fact that some witnesses may fail, and that could persuade one juror. And I've experienced situations where you have the one holdout and they stick true, and hung juries do result.
So do you think that we might even see some jury nullification here, like, hey, get back at Wall Street, and all he did was rip off a bunch of very rich people, so to speak, and we got to stick it to the man. Do you think that at some point defense will change its tactic midstream if they see that things are not going their way?
Well, I think that they'll try, but I think the prosecutors are aware of that, right? In the first day, what did they do? As one of the initial witnesses, they called someone who lost $100,000 in the investment, and a modest investor, someone who is sort of a day-to-day type of investor in crypto. And while the defense tried to paint them as, well, you understood the risk, the fact of the matter is that this was sort of an ordinary, everyday citizen who lost a substantial amount of money. And I think you're going to see that in the prosecution's case, that they're going to try to humanize this, make it about not the celebrity aspects of the people who lost, but the fact that the losers in this are everyday investors.
All right, Michael, thanks for joining the show this morning. It was a pleasure having you back.
Thank you.
That was ZFZ Law co-founder Michael Zweiback.